So oftentimes you're faced with an option of settling the case or taking the case to trial. And it's a difficult decision to make, one that ultimately lies with the client, but you guide them along the way. And the way that I see it is, at least personally, I think about other cases that I've either worked on myself or I've seen other attorneys work on that have similar facts and what they resolve for. And I kind of use that as a gauge for where I think the case should resolve. And if we have an offer on the table that's nowhere near that range or within that range, then we're not resolving the case. I'm going to tell my client this case deserves to be tried. I think the jury's going to be very receptive to it, and we push forwards. However, if the settlement comes in within a range that I think is fair and not worth the risk, I'll advise the client accordingly. But I don't like my clients leaving money on the table when their case is worth more. When my clients trust in me, I like to push it as far as I possibly can to get the full amount. Because a lot of times, and what people don't realize, is you're not going to maximize the value of your case most times within the first 6 months. You have to litigate for a significant amount of time, and often the best offers and settlements occur right before trial or maybe right after you impanel the jury. You have to get to that point. You have to do all the work and show that you're fine going the distance. That's when the real money gets put up. Not in the beginning, unless it's like a super clear case, super clear liability, high damages, then you can resolve it earlier on. But a lot of these cases are litigated all the way to the end. So it's basically a judgment call when you get the settlement offer. Work with your client, see what they need to make a full recovery and get back on their feet, and then you make the call and you stick to it.